It's Entertainment Law Update, episode 174 for November 27th, 2024. Welcome. Hello, everybody, and welcome to this episode of Entertainment Law Update from Los Angeles, California. I am Gordon Firemark.
Well, and from the Nashville Metroplex today, I'm Tamera Bennett.
And that explains why you're in a different scene and it doesn't look as
Exactly
pristine as it
right.
usually does.
Yes. Option A did not pan out, so we may be down to option B or C
as we
today
said,
for
it's
recording.
the day before Thanksgiving, and you've done your traveling and visiting family for the holiday and all that jazz, so that's wonderful. And yeah, we're glad that everybody's able to be with us. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis. And as always, we start out a little chit-chat. This episode is being recorded on the day before Thanksgiving, so it's a great time to give thanks, to express our gratitude to our friends and colleagues and audience. And you folks are the reason that we do the show. So we're really glad to be able to do this for you and to have the opportunity to come into your ears and now eyeballs from time to time. So thanks.
Yes, and you probably just watch as Tamera travels.
Well, speaking of travel,
as we're at different. Yeah, speaking of travel, you came to Texas and I wasn't there.
I missed you. I had a great time.
I missed you.
Entertainment Law Institute in Austin last week. It was wonderful, and I got to see friends and colleagues, and too many to shout out by individual names. But I did share the stage with Stephanie Hay for our panel about the aftermath of the 2023 WGA and SAG-AFTRA strikes. And it was great, as always, to see Stan Sucher and have him do his wonderful annual case law roundup, and a few other familiar faces and a few new ones. It was really nice to meet everybody. And congratulations to this year's Texas Star Award winner, Joy Barnes, who I've known of peripherally for years. And so it was nice to actually meet her and get to talk with her about things. And that was good. So what's been going on with you?
I have not. Yeah, I was say I have not had the opportunity to meet her, but I enjoyed hearing her present. Also going to say congratulations to Terry Lacona for he was the recipient of the Cindy Lazari Award. Terry has produced for the last 40 years Austin City Limits. I don't know if you were still there for his presentation. It was the last one on Friday. Anyway, it was a great interview about the history of Austin City Limits, and then the presentation prior to that was a legal conversation and business conversation about how shows on PBS work and booking talent on PBS works. It was fascinating.
I had to leave after the presentation and before he received the award, so I wasn't able to hear his interview. But it was a wonderful time, and they put on. But I loved
your and Stephanie's conversation in CLE. It was so helpful.
Oh.
You always give helpful CLE, but I just found it to be obviously SAG-AFTRA things sometimes are a little tangential to what I'm doing, but just it was a good basic understanding and details of the new agreements. So anyway, I'm just encouraging folks, at some point this will be available at UT Law CLE to view after the fact and acquire CLE credit. So just watch out for that. There's lots of great
little secret.
Available.
I mean, kudos to Stephanie, who really stepped up at the last minute. We had another panelist, and she was going to moderate the conversation, and we found out at the last minute that panelist is no longer with SAG-AFTRA and therefore wasn't coming. So we had to prepare.
Okay. Well, Stephanie did great. Stephanie's a friend and colleague. She's really did a lot for the section the prior day for the intro, and so all good. This is the first, other than COVID years, this is the first year I've not been there in person in a long time. So I was sad to not be there.
You were able to do the live stream.
I was able to do the live stream, and one of my good friends was also watching the live stream. So at 5:00 on Friday, I called her And
Oh, nice.
we kind of had a post phone
Post.
call event.
Nice.
It was really good.
Nice.
So anyway, what are you up to next after the new year starts? Where are you
Well,
headed?
I will be, it's hard to think about it. It's 2 months away still, but I'll be speaking at the Podfest Expo in Orlando, as I do most years, in mid-January. And I'm talking this time a little bit off the podcasting subject about legal and business considerations for online course creators. So that's an area that is
interesting.
close to my heart as an online course creator myself. And a lot of podcasters are monetizing or using the podcast to drive traffic to their courses and things like that. So it's a good crossover.
Oh, make sure you just, if you don't have it on your agenda, talk about the copyrights in those course materials and if they can be downloaded or not downloaded and what's publication and what's not publication, and all of that is a very confusing
and just
issue.
how to register for a copyright for an online course.
Right.
It's a challenge.
Yes, very. As long as they don't allow them to download them, it becomes easier.
Yeah. Oh, because it's not a published work.
Because it's not a published work.
Yeah. Well, anyway, so that's what's going on with me. Do you have any travel or appearances planned in the early part of the year?
I don't. I'm always open for new opportunities, but not anything set up right now to talk about. So I'm sure there will be others we'll be talking about as we move along through the coming months.
Okay. Well, let us start the show then and get into our subject matter. With a discussion. We'll talk about we'll wish you all a happy Thanksgiving, first of all, and hope everybody has a great holiday weekend. Oh, I saw the Wicked movie too, and if anybody hasn't seen it yet, this movie is better than I could have hoped for, and I am a giant Wicked fanboy. So,
and well, did you sing?
I didn't sing. I let the audience enjoy the professional singers in the movie. And
did you costume?
No, I didn't costume.
Okay.
But, I wore my Wicked sweatshirt.
Okay.
And my wife and I bonded on our second date over the soundtrack for Wicked. So it has special meaning in our lives, and our kids had never seen it. So we got to take them to see the movie, and the teenage ambivalence thing was definitely on display, but I think they really did enjoy it. So
well, then the nice thing, I enjoy Wicked. I'm probably not as big a fan as you are. I really want to go see the movie. I've seen the stage production 2 or 3 times, but they're always spread out enough that I forget things.
Yeah.
So I always have a delightful surprise every time I see the stage production. So anyway, I look forward to watching.
And I look forward to following up with you about it after you've seen it. So anyway.
Oh, okay. Yeah, I've been reading about how they made sets. So let's talk about what we need to talk about.
8 minutes in and we haven't talked about a legal case yet. Anyway, so here we go. OpenAI, this is our AI corner, I guess you could say, for this week, this month. OpenAI has won a case against some of the news companies on the basis that there's basically been a lack of any real harm. Initial victory in one of the many lawsuits the company is facing for its unlicensed use of copyrighted material as training data set for the generative AI products like ChatGPT. And they've had some interim triumphs along the way, but this is really the first win that actually addresses the matter of copyright management. The plaintiffs are media outlets Raw Story and Alternet. They alleged in their complaint that thousands of the news outlets' copyrighted articles were scraped from the internet and stripped of their author, title, and copyright information, and then input into at least 3 of the training sets used by the tools. And then they were used to train the chatbot and ChatGPT, and therefore ChatGPT's generated responses included information gleaned from the copyrighted works without identifying the source. And the news sites argued that removal of copyright management information, CMI, prior to training the tools constituted a violation under 1202B1 of the the Digital Millennium Copyright Act. And they sought an injunction to stop OpenAI from generating infringing responses through the current version of ChatGPT. And OpenAI argued the plaintiffs didn't have standing because they hadn't demonstrated a concrete harm to their businesses that was caused by the removal of the copyright management information. And they also alleged that the court lacked subject matter jurisdiction over the case, which I don't know about that. But the plaintiff said the removal of the CMI constitutes a concrete injury in and of itself, and that the injunction was warranted because there was substantial risk that the new version of the tool would generate either the copyrighted works verbatim or nearly verbatim. But OpenAI argued that neither theory of harm identifies a concrete injury. In fact, sufficient to establish standing, and the court agreed. The case, that question of concrete harm really was central in this early disposition of the case, and the court looked at the definition of concrete harm set forth in a 2021 case, TransUnion versus Ramirez, which established that a mere violation of a federal statute on its own is no longer enough to open the courthouse doors. So statutes that provide for statutory damages without proof of actual harm have limited power, and that is the Copyright Act. That's really an interesting take. They said that unlike a
very
typical,
interesting take.
Yeah, unlike a typical DMCA Section 1202B case, in which copyrighted works are stripped of the CMI and then reproduced verbatim, generative AI models don't reproduce the works directly. They synthesize the relevant information from that underlying data to generate new responses. Given the quality of information contained in the repository, the likelihood that ChatGPT would output plagiarized content from one of plaintiff's articles seems remote. And the plaintiff submitted evidence showing earlier versions did not output plagiarized content, but plaintiffs
I think they showed earlier versions did output plagiarized.
Yeah. And the plaintiffs have not plausibly alleged that there's a substantial risk that the current version will generate a response plagiarizing one of plaintiff's articles. So the response, they relied entirely on 1202B instead of straight ahead copyright infringement. So the alleged injury is not the exclusion of CMI defendants from the training sets, but rather the use of the articles to develop ChatGPT without compensating plaintiffs. So the court did leave open the possibility for an amended complaint, but the opinion makes it look like a pretty uphill battle for the lawsuits that involve the CMI side of things, if this interpretation of Article 3 continues to apply. So,
but so then I'm just wondering, how could this play out just in general copyright infringement? If you're alleging statutory damages, obviously you have to allege and prove harm.
Yeah.
But
isn't the being deprived of your right to control the exclusive rights to your work a concrete injury? Doesn't have to be an injury measurable in damages, as far as I read it.
Because that's why you have statutory damages instead of, if you're able to fall under that, instead of being able to prove actual damages.
Right.
So,
but it seems to me that removing the CMI is a derivative work, so you could argue an infringement on the basis of that exclusive right outside of this DMCA provision, maybe.
Or
but
they
again,
could file for the, what's the damages for removal of CMI? $2,500, $2,400?
I don't know. Something like that.
I mean, there is a set amount for removal of CMI under the DMCA.
Yeah. So, it may be something that can be pled better in future cases, but it may also be something where there needs to be if the intent of Congress and behind the law is to make it actionable, the removal of the CMI actionable, notwithstanding any lack of concrete harm, I guess they'd have to come up with some new statutory language or something to carve it out. I don't know.
Right.
But this is interesting. We're living in interesting times, aren't we?
We do. And I mean, I'm constantly either planning ahead or drafting around any content licensing I'm doing related to AI, so that at least a third party who might be acquiring rights can't actively go out and submit it to AI. It doesn't mean
Right.
the chat GPTs of the world couldn't still
Yeah, I mean,
ingest
I've started
it. So
putting a restriction on the use of the material as training data for AI in,
that's
website terms of service and any other, contractual scenarios that I can think of. It's becoming a sort of a routine part of the boilerplate now, and
and I just saw my first contract where the third party specifically stated, and by the way, we can use your copyrighted material to train AI.
yeah,
And I was like, no, actually, you can't.
yeah. Let's draw a big line through that sentence.
Yeah.
Right.
There was a big red line happening there. So,
Well, another
but
big
what's happening with OpenAI? Yeah.
Yeah, well, so OpenAI is also being sued by the New York Times. It's actually, the caption is Times Company versus Microsoft Corp et al. But it's the New York Times is accusing OpenAI engineers, the OpenAI, of using its articles, and they had, in their early pleadings, they had shown some proof that OpenAI was generating almost or verbatim articles when prompted properly. And I guess it was a discovery order of some sort or something that led OpenAI to give the New York Times a virtual machine access to their training data set so they could mine it and look for evidence, I guess is what was going on. And apparently in a motion to the court last week, the New York Times alleged that OpenAI had somehow done some kind of a reset that deleted all of their 150 hours of lawyers' work digging through the data and rendering the whatever they were generating inadmissible in the case. So they've gone back to court looking for
Wow.
sanctions and all that. And OpenAI responded saying it wasn't intentional, it was a mistake, we'll take care of that kind of thing. So
Okay. Yeah, it was interesting. What I had read as well was that they were going in, and I don't know if this was a separate review, because this was to actually look at source code for ChatGPT, that the Times lawyers had to badge in and out of a secure room where everything was on a computer, not connected to the internet. They could only share their findings with 5 outside consultants, so that may be a separate review from the actual document review.
Okay. Yeah.
To figure out if maybe how the source code is working. So it sounds like there's a lot of nitty-gritty going on.
Well, and these technology cases are, of course, very technical. So, yeah, they're looking at not just the source code, but according to our notes here, they've spent about 150 hours combing through the training data during the first couple of weeks of November, and now they have to repeat all that work. So I don't know. Maybe there will be a sanction involving attorney's fees for those 150 hours.
Attorney's fees.
Or something like that, if not a terminating sanction, although that would be extraordinary, I think. So,
yes.
So the AI saga continues, I guess we could say. So anyway, you want to take this Ghost Adventures story?
I do. Lizzie Gordon. I had to kind of remember the story of Lizzie. Lizzie. Did I say Gordon?
Yeah,
Gordon.
I'm
Lizzie
Gordon.
Borden.
She's Lizzie.
That's right. There you go. So this is U.S. Ghost Adventures, LLC, USGA, operates a museum and bed and breakfast at the Lizzie Borden House in Fall River, Mass, featuring ghost tours, historical exhibits, and the USGA does hold trademarks for the Lizzie Borden name and distinctive hatchet logo. So in real life, Lizzie Borden was infamous for the allegations that she murdered her father and her stepmother, and I guess in this home.
Yeah.
So Miss Lizzie's Coffee opened a coffee shop next door to the Lizzie Borden house. The coffee shop's using marketing materials that includes references to Lizzie Borden. They have their own unique blood spewing hatchet logo. That just sounds appetizing for coffee. USGA sued the Miss Lizzie's Coffee for trademark infringement, alleging the cafe's use of the Lizzie Borden name and imagery created consumer confusion, as well as an affiliation between the businesses, and diluted these distinctive trademarks they own. They sought a preliminary injunction to stop Miss Lizzie from using the branding of the boarding house, and the district court denied that injunction, finding USGA unlikely to succeed on the merits because the coffee shop's branding was not sufficiently similar to theirs. There was no confusion. The business catered to distinct audience, and the businesses, both of them, catered to distinct audiences, and the cafe's use referenced the historical figure, not what's in the USGA's marks. On appeal, they looked at two issues: the likelihood of confusion as well as trademark dilution. And the First Circuit upheld the district court's ruling, agreeing that USGA failed to demonstrate confusion, relying on the Boston Duck Tours test from 2008, examining factors as to the similarity of the marks, the evidence of actual confusion. There must be a quote, a likelihood of confounding an appreciable number of reasonably prudent purchasers exercising ordinary care. They said that there was a distinction in the design elements of the mark. It's also Miss Lizzie's Coffee. It doesn't include her last name. And she's a historical figure.
Yeah.
Was a real live person. They also didn't find any trademark dilution. And the First Circuit affirmed the district court's denial of a preliminary injunction, ruling the USGA did not sufficiently prove, again, likelihood of confusion or dilution. And the court emphasized the importance of protecting trademark owners' rights without unduly restricting legitimate use of historical and thematic references in commerce. So that's kind of interesting. So if I wanted to open up Sherlock's Coffee next to the Sherlock Holmes,
Yeah.
you think it sounds like I can, even though we know that factor is litigious in protecting
and I mean, it's sure
the Sherlock Holmes branding.
Yeah, at first blush, it sure seems like, coffee and a bed and breakfast are, going to be rubbing up against each other in terms of category class of goods and services.
Oh,
hospitality.
They are.
Yeah. So I can see why the case moved forward, but I don't know. I'm a little surprised by this outcome. But I imagine it was sort of fact specific. Hey, nobody was actually confused, and the two logos are different, and it is just Lizzie and not Lizzie Borden mentioned. I wonder, could two banks use Benjamin Franklin's name to operate, and or a bank and a investment management service, or who knows,
Okay. And I was just saying my analogy was not a good one because Sherlock Holmes is a fictional character, not a real character.
Well,
but do you remember, or maybe you didn't have it, we had Benjamin Franklin like dollar stores.
No, I didn't know
years
about
ago.
that. Oh, interesting.
Yeah, we used to have that. So maybe that's just a Tennessee kind of thing, a Southern thing.
Maybe. I don't know.
Probably. I don't know. So I think this is a good one to follow. Is it going to be just kind of a one-off in the First Circuit? I don't know.
We may find out at some point. It was an interesting ruling, so that's why it made it into the rundown. So let's talk about Ed Sheeran and Let's Get It On and the Thinking Out Loud copyright infringement lawsuit that we all thought was over, I think. but you remember earlier this year, or was it last year? Ed Sheeran won in a jury trial where he actually played some music to the jury from the witness stand and showed them himself how these components that were allegedly infringed were sort of fundamental components of all music.
Right. And I think the reason we thought it was over was because from a procedural standpoint, there were two cases running parallel paths.
Right. So structured asset sales.
And one was resolved and one wasn't. Yeah.
Yeah. Structured Asset Sales, LLC, is the plaintiff in the case we're talking about today that had sort of missed an opportunity or hadn't taken an opportunity to join in that earlier case. I don't know if it had factual differences enough to make it need to be separate, but anyway, it ran as a separate case representing a small fraction of a portion of the royalties. Let's see, what is it? Structured asset sales is one of these companies that monetizes and securitizes interests in intellectual property, and they had purchased some portion of the copyrights from certain members of the estate at some point. Anyway, so as a co-owner of the rights, the structured asset sales belatedly sought to join that Griffin lawsuit, but the district court denied leave to intervene. So separate suit moves forward. And the elements, the case was about certain elements, the chord progressions and harmonic rhythms of Thinking Out Loud, infringing on the copyright in the Marvin Gaye tune "Let's Get It On," written by Ed Townsend. And the district court had initially denied a motion for summary judgment, but then reconsidered and concluded that the chord progression and harmonic rhythm of "Let's Get It On" were too common to be protected under copyright law, and ruled that only the elements in the sheet music registered with the Copyright Office in 1973 were relevant. So additional expert testimony about the inferred musical elements was excluded, and summary judgment in Sheeran's favor. SAS appealed, and the issues on appeal were the scope of copyright protection, and the Second Circuit affirmed that the protection was limited to what was on the sheet music, as per the Copyright Act of 1909, emphasizing that copyright law doesn't extend to inferred or implied elements not expressed in the registered material. And the originality of the combined elements, SAS had claimed that the combination of those chord progressions and harmonic rhythm was original and protectable. The court rejected that, citing a Ninth Circuit case, Skidmore versus Led Zeppelin from 2020, that had held that
that's our Stairway to Heaven case.
Yeah. Requires a numerosity and originality threshold to warrant protection, and for a combination of unprotectable elements to be eligible for protection, they have to be numerous enough and the selection and arrangement original enough that their combination constitutes an original work of authorship. So the Second Circuit said no, doesn't meet that standard. And on substantial similarity, the court found significant differences in melody, lyrics, and other elements, making it unlikely for a reasonable jury to find substantial similarity. So the elements that SAS had identified in the Thinking Out Loud song as similar to Let's Get It On, the harmonic progression and rhythm, were not unique enough to be copyrightable on their own. So the decision is reinforcing these limitations on copyright law and protecting these fundamental building blocks of music, such as chord progressions and rhythms and things like that. So no infringement.
Right. And we've talked about this before in the Skidmore case, as well as we've had conversations on this, for these works in which the requirement was to file sheet music with the copyright. They are very, very limited. Whereas today, that is not the requirement for what you file with a song. I mean, you could still file sheet music.
Yeah.
But I think the majority, I don't know, probably the Copyright Office has a statistic on this, but I suspect most likely a recording is submitted. And while it may have been a bare bones demo, I always recommend, if it goes from a bare bones demo that you filed for registration and then you do a full blown production, but we want to file that as a derivative.
Yeah, I mean, I think this is definitely an evolution of the thinking about what is the work. And now we know. So if all you've got is sheet music, you're very limited in what you can do.
Right.
Yeah. So
okay, so here's an interesting one out of Kentucky. Gosh, have we had cases out of Kentucky?
If we have, I didn't remember
we very
them.
often have one. So to my colleagues to the north of me today, a recent decision by Kentucky U.S. District Court affirmed that federal courts have jurisdiction to review and, get this, potentially cancel pending trademark applications in certain circumstances. This provides an alternative to challenging trademarks exclusively through the USPTO, or shall I plug this in to say, to challenging trademark applications exclusively through the USPTO.
Yeah.
The company Rudy Green makes and sells frozen human-grade dog food in stores in the U.S. PetSmart, a chain of pet stores that sells all kinds of pet products and services and pets as well, are the parties. The companies met in 2008 and in 2021 to discuss selling Rudy Green's products in the PetSmart store. Never came to an agreement. In 2023, PetSmart sought to obtain a trademark for Rudy's to advertise their rawhide dog chews. So the company Rudy Green sells human grade dog food, PetSmart trying to sell dog chews. The PTO rejected PetSmart's application. So I'm sure they issued an office action, went through the whole process, made it final, saying the registration's already owned by Rudy Green. We're blocking it. Then Rudy Green sued PetSmart this year in May, alleging the following for trademark infringement and sought to cancel PetSmart's pending trademark application. The court ruled it has the authority to address pending trademark applications when they are closely tied to ongoing litigation, even though the Lanham Act explicitly mentions jurisdiction over registered trademarks, not pending applications. Two key provisions of the Lanham Act were under scrutiny. Section 37, which grants the court authority to determine the right to registration and to rectify the register, but only mentions registered trademarks. And then as well, Section 39, granting federal courts jurisdiction over all actions arising under the Act. The Kentucky court noted there was an ambiguity, stating that while the Lanham Act applies explicitly to authorize courts to cancel pending applications, the broad language of sections 37 and 39 allow the court to determine registration rights, which could imply a power to address issues related to pending applications when closely tied to that subject matter of litigation. The decision relies heavily on the case, the 1976 Continental Connector case, which established an exception allowing courts to intervene in pending applications if they are sufficiently related to registered trademarks in litigation. The court found the pending application, quote, sufficiently related to Rudy Green's registered trademarks, while the USPTO's citing the initial refusal for registration based on the likelihood of confusion. The court emphasized that trademarks need to only be, quote, sufficiently related, not identical, for the exception to apply. So, does this lower the threshold for determining potential confusion? Because this is saying if the examiner said it was confusingly similar, and I don't know if they went through the process and had a TTA proceeding, probably that was stayed while they did federal court proceedings. But it says federal courts can serve as venue to challenge trademark applications. But I'm wondering if that's the only thing you're challenging, if you can actually open the courthouse door. I think you have to have the courthouse door open for litigation to get in front of the judge for that.
Isn't there a rule, though, that you have to exhaust your administrative remedies before you... Well, no, I guess that's only certain kinds of cases, but it seems to me that this is a court stepping into an administrative agency's role, at least in part. I don't know. Is this a district court ruling or an appellate level? I think it's a district court. So we may see an appeal.
District court.
Yeah.
And is that even the correct court? So it's not unusual to see TTAB proceedings stayed while
litigation is pending
while litigation is pending. But that's going to typically be, I think, there's a cancellation action pending. Maybe there's an opposition action pending, which would be in the case of a unregistered in an application. So I don't know. I'm interested to see if we get a response from the trademark office or if they weigh in on this if it goes up on appeal. So we
Well, I
will
mean,
see.
it is an interesting precedent to set if it sets a precedent, that trademark holders would use litigation instead of opposition proceedings if they think they've got the evidence in the case. I don't know. I don't know why anybody would choose that. It's the more expensive, more time-consuming option in most instances. But maybe people aren't happy with how the TTAB handles things.
Well, I'm just wondering if it's the option that they think would pressure people into a resolution faster. But clearly this one didn't.
True. Well, listen, on the trademark litigation front also, we have the closely watched case involving trademark law and sports merchandise. A Pennsylvania jury has awarded Penn State University a whopping $28,000 in damages after finding that Vintage Brand and Sportswear Inc. had willfully infringed the school's trademarks. The company, formed by former minor league baseball player Chad Hartvingson, sold vintage-themed apparel featuring Penn State's logos, and that prompted the university to sue and allege trademark violations and the sale of counterfeit goods. What's significant is it's the first in a string of similar lawsuits filed by universities, including Purdue, Stanford, UCLA, against Vintage Brand and Sportswear. While those cases have yet to reach trial, Penn State's victory provides a critical test case for the trademark owners looking to protect their rights. At the heart of the dispute was whether Vintage Brand's use of the Penn State logos could be considered an ornamental and non-infringing use. That was the defendant's argument, and whether the use was likely to confuse consumers into believing the products were affiliated with or licensed by the university. And ultimately, the jury found in the university's favor, rejecting the claims that they were merely decorative or ornamental. Now, it should be noted, I think these logos in question were not the current modern version of Penn State's logo, but they were sort of vintage versions. And so maybe that was part of the not confusing argument. But if Vintage Brand had won, it could have opened the floodgates for lots of these third-party vendors to use these institutional historical marks without permission and undermine the control that universities and sports teams have over their branding. So this verdict, though, does reaffirm the enforceability of those rights and the strength of licensing frameworks. So modest damages, but it does set the sort of standard. The verdict reinforces the school's ability to protect its intellectual property and as a signal to other unauthorized sellers that even vintage or retro designs could run afoul of trademark law. So I think it's reasonable to expect we'll see similar rulings in the Purdue, Stanford, and UCLA cases, although they'll be in different courts, which could be an interesting, could set us up for some interesting times.
And I get this kind of this ornamental, I suspect I buy a t-shirt and, what's in the neck or on the hang tag says Vintage Brands. That's the brand, that's being sold. But then it has the design on the front of the t-shirt. And I guess that's the argument. Oh, we were merely using this as a decorative fashion. But I think people would be confused that somehow that was a licensed activity.
Yeah.
So, and obviously the court did too.
Yeah. Well, I mean, and here's another scenario. Mickey Mouse is now in the public domain. So you put him on a t-shirt or a sweatshirt, Disney's going to have a problem with that. They're going to say, wait, that's our brand.
Because they have a trademark.
Yeah, exactly.
That's right.
So it's sort of the same idea here. Yes, it's ornamental. It's a picture of Mickey Mouse, but it does suggest a connection between the companies that doesn't exist. So,
That's right. So here's an interesting case of where the worlds of literary rights and music rights are overlapping with one another. Dealing with audiobooks that you can listen to on Amazon and Spotify, which I have a paid account. So, I'm like, oh, this is cool suddenly when I have access to these audiobooks showing up on my Spotify account in the last year or so. But in May 2024, the Mechanical Licensing Collective, the MLC, that's the entity set up under the Music Modernization Act to collect digital mechanical royalties, sued Spotify, challenging Spotify's decision to include 15 hours of audiobook content within its premium subscription plan, calling it a bundle under Section 115 of the Copyright Act. The central issue is whether Spotify's premium service that they're offering qualifies as a, quote, bundled subscription offering, a classification that impacts how royalties are calculated under phonorecords for rates. MLC alleges that Spotify began offering audiobooks in November 2023, so about a year ago, without proper declaration of a bundle or an accompanying price adjustment, and this went on until March of 2024, resulting in a significant reduction in royalty payments for music creators. According to the MLC, this move decreased, well, it would have been songwriters' royalties by rates of nearly 50%, and they are seeking $150 million in damages to address this alleged underpayment. Spotify counters that the price increases in August 2023 and July 2024 demonstrated bundling, quote, well, I'm putting air quotes, intentions, and maintains that audiobooks add distinct value, satisfying the requirements for a bundle. A court ruling will hinge on whether audiobook services qualify as more than a token addition to what is traditionally a music streaming platform. Then we look over to Amazon Music, also has introduced a bundling feature, adding Audible audiobooks to its Amazon Music Unlimited plan. But unlike Spotify, Amazon's approach has been actually welcomed by the music publishers. I guess they asked for permission first, maybe? Anyway, the National Music Publishers Association praised Amazon for consulting with publishers and establishing fair pricing structures before launching. The contrasting reactions to Spotify and Amazon, highlight the different approaches. The whole time we've talked about Spotify over the last, have we been talking about Spotify for a decade? It's always ask for permission after the fact, ask for forgiveness, not ask for permission.
Yeah, it really is fundamentally a philosophy thing,
my perceived business model.
Yeah.
Yeah.
Well, you know,
we'll take a look.
Yeah. I am.
Did you notice that, or on those services that you could now have access to audiobooks?
I am not a subscriber to either of those services.
Okay.
So,
okay. I finally had to give in on Spotify for work.
Yeah.
I
listen to the ad-supported version of Spotify, and I'm perfectly happy with that.
Yeah.
The free tier.
There's just so much I need from my client's perspective. I was like, I don't want to pay them, but if I'm going to do this, at least my clients are getting paid something.
I'll tell it to the IRS,
and my people who are not my clients who are getting paid something, something more by me subscribing. So anyway, that's a push-pull all the time.
Yeah.
And then we also have more related to the MLC, related to new streaming royalties for mechanical rights.
Yeah.
So anyway, do you want to handle that, or I can discuss it?
Well, the Copyright Office has finalized a new rule that ensures that songwriters who reclaim the ownership of their music by termination will start receiving streaming royalties directly. And this has been a sort of long-standing point of confusion, I guess, over the prior policy at the MLC back in July. So obviously the previous policy caused a lot of disputes and controversies because it allowed royalties to continue flowing to the former rights holders if the songs were uploaded to the streaming platform before the copyright was effectively terminated. So the critics argued that this really undermined the value of the termination right, depriving songwriters of the benefits of reclaiming copyrights. So the new rule now mandates that the royalties from streaming have to go to the copyright owner, the post-termination copyright owner, pretty much immediately. So that overturns that prior approach. Also requires corrective royalty adjustments for past payments made under the old policy, although that's expected to be fairly modest. They're estimating around $2 million or so. Advocacy groups for songwriters, including the Music Artists Coalition and the Recording Academy, really championed the new rule as a landmark victory that upholds creators' rights in this digital age. And the music publishers were initially critical of the change, but ultimately supported the final outcome because it provides clarity for the MLC and the industry and ensures a proper distribution of royalties and minimizes disputes over these termination-related payments. So good news for songwriters.
And I just want to put a practice pointer out here on this. So if you or your family or whoever are filing copyright termination notices under the two different sections of the Copyright Act to reclaim the copyright for the U.S. rights, and you go through that process, it's effective, it's not challenged by the recipient of that notice, you still have an affirmative duty to contact, let's say you're a songwriter, the MLC, BMI, ASCAP, whoever your performance rights organization would be, to notify them that this termination, that the effective date has occurred, for exactly which musical compositions this occurred, so that they can update their records appropriately. If you don't make those affirmative steps, they don't have an obligation to make a change because they haven't been received notification there should be a change. So just take a look at that. Make sure that's happening. So if you're the party filing those notices when the effective date rolls around, that you're taking the next step to
it's not the responsibility of the previous owner or operator of the user.
That's right. It's not their responsibility. So well, we've got some exciting, well, I don't know if it's exciting news.
Important news.
Stressful news? Important news from the U.S. Patent and Trademark Office.
I had a little hard time making heads or tails of this, but the new fee structure.
I actually found a summary that I believe is correct, and I posted it in the link.
Great.
That helped me understand, because I, like you, had a hard time reading what the Federal Register and the Trademark Office put out to really figure out what was going on. But anyway, plan ahead, folks. January 18th, there's a change coming. The USPTO has reconfigured its fee schedule, and I put hopefully to better serve and provide innovation for its stakeholders. This applies to any filings made January 18th and later in 2025. The USPTO is, quote, introducing surcharges for applications that are incomplete or contain custom identifications of goods or services. This application surcharge aims to encourage more complete applications while improving examination efficiency and reducing pendency. So what is this going to look like? There is a new fee for a base application per class of $350. You know, we used to have this, or we still have this kind of tier depending on how you chose to file your application. If your application is reviewed and insufficient, you could be hit with $100 per class because you didn't provide sufficient information. If you decide you don't want to use the pre-generated description of goods or services, add $200 per class. And if you need to use more than 1,000 characters, I guess, to describe your goods or services, add $200 per class. I typically see that with a lot of the foreign filed applications are out of control. I typically use the Test Plus system when I file. And the word is, if you're used to using that, you probably will not see a whole lot of difference in what you need to include in your application.
Except for an extra $100.
That's right. But except an extra $100 in the filing fee per class. But if you want to avoid this insufficient information charge, okay, you need to make a color statement if you're claiming color. If there's a translation, you need to put a translation statement. If there's non-Latin characters, if there's an individual's name or likeness, you need to notify and mark that appropriately with whatever needs to be included. There's also fee increases for all of the post-registration maintenance filings, as well as a fee increase for extensions of time to file a statement of use. And the letters of protest, that fee actually went up substantially. But if here's my practice pointer, if you know you've got to file a statement of use, an extension of time, or even an application, you may want to get it in January 17 or sooner on behalf of your client, just to
Yeah.
avoid some of this change in filing fees, especially if you've already quoted a flat fee and now there's an increase in fees.
Yeah.
Um, one practice pointer was you may just need to be better about gathering information from your client before you file an
Hmm.
application, which
Hmm.
I would highly recommend. And over the years, I added to my questionnaire, is this the word in foreign language? What does it
Oh, interesting.
translate to?
Yeah.
I asked that, what does this word mean?
Well, a shout out
And
to
then,
Alt Legal. I just want to give a shout out to Alt Legal. That's where the
yes.
summary that you link to is. I use Alt Legal for my trademark
Oh,
intakes, and they
okay.
ask those questions in their intake form. So it's a
Oh,
very good,
interesting.
yeah. And what's really cool is that if you use their intake form and then you log into the USPTO, they have a plugin for your browser, so you can click fill, and it will populate the information with the information you or the client have completed in the Alt Legal form. So
And
it saves you some time.
can you modify what the client puts into the alt legal form? Especially, so let's say your
Oh yeah.
client says, they give you their layman's description of their goods or
Yeah.
services, and we now know it's really important to pick a
Yes.
approved.
Yeah. And
Interesting information.
yeah, and what I do is I say to the client when I send them and it's an email, it's a web form, so I send them the form, and I say, if there's anything you don't know, give it your best shot at the answer, or just leave it blank, and then we'll go through it together. And that's a 10-minute phone call usually, and then I'm able to go and file the application, and it works
Yeah.
really, really well.
And I've created my own form
Yeah.
and do the same thing and
Mhm.
intake it, but then we don't have a direct one-to-one to putting it directly into the application. So I may have more conversations with you
Trademark docketing tool.
as to
It's
how
good.
that works.
We should see about
Yeah.
getting
So,
them as a
and
sponsor.
we should see about that. And so, literally a real-time update. This email came through in the last hour or so before
Oh,
we jumped on to start recording today, that the November 2024 version of the Trademark Manual of Examining Procedure, the
oh,
TMEP, is now available on the USPTO website. It incorporates relevant presidential decisions issued since May of this year and revisions that happened before August 31, 2024, revises some language to make it general neutral, replaces references to older systems and new systems within just the trademark and the appeals process and the TTAB process. So I use the online version directly from the USPTO, so
mhm.
I'm guessing that's already updated. But if for some reason you're using a different resource, make sure you have the current version of the
Little
TMEP.
light reading for the holiday weekend, right?
Yeah, lots of fun, lots of fun.
Oh man. Well, a little shorter episode than our usual, but that's fitting and reflects the pace of things this last month or so. But that brings us to the end of this episode of Entertainment Law Update. So as always, a big thank you to you, our loyal listeners, for spending your time with us, and we wish you a very, very happy Thanksgiving holiday for those in the US that celebrate the holiday. And if you have any feedback for us, and we love it when you do, please leave it for us on the voice widget on our website at entertainmentlawupdate.com, or send us an email, entertainmentlawupdate@gmail.com. I'm no longer using Twitter, just got tired of the kind of echo chamber it is, but the Ent Law Update is the handle on the Twitter account if you want to check that out. And Tamara, thank you again, as always. I'm grateful to you for you're part of this show and the friendship we've built over these years. Tell listeners how they can find you.
Yeah. Well, online at Tamera Bennett, most social media, tbennettlaw.com or createprotect.com will take you to my website, my blog, another way to access the links to the podcast as well. And Gordon, happy Thanksgiving to you and your family.
Thanks.
Always so grateful for your friendship, our collegial professional
Mm-hmm.
relationship we have. And if I don't say it enough, everyone knows you're the technical support behind making this happen. If you're watching on YouTube, you really understand that today. So
She's saying I'm a geek,
happy
folks.
Thanksgiving. Yeah, yeah. Well, I'm a nerd. I'm just not a geek. Maybe that's the difference. I don't know.
Oh, wow.
Happy Thanksgiving to everyone, and just our deepest gratitude to our listeners, our viewers, our colleagues who, see us out and about at events and send us emails and give us great updates on what's happening in the world of intellectual property and entertainment law.
We do appreciate the tips and the pointers and things like that. I'm Gordon Firemark from Los Angeles, and my website is at firemark.com. The email address is gfiremark@firemark.com. And on most social media websites, gfiremark is where you'll find me. So let's also give a big shout out to our team of volunteer contributors who always do a fabulous job helping us get the show ready for you. Managing editor John Janicek is sort of the leader of the team there. Charles Thorne, Alexis Allen, Violet Zhang, Tasha Spear, and Dawson Holder also are integral parts of the team. And listen, if you are interested in joining the fun as part of the ELU family of contributors, join us. Reach out. EntertainmentLawUpdate@gmail.com is the address for that as well. And would love to hear from you. Send us a quick cover note and a resume, and we'll be in touch. So, and so that's going to do it and wrap up our episode of Entertainment Law Update. Thanks again for listening. And until next time,